I think we are having only 3 students for this program.
Okay.
One student has joined.
Yeah.
May I know about yourself? Jacqueline Jackson. Hello.
Hello, sir.
Is it possible to on your video? Yeah,
Yes,
please.
yes.
Please introduce yourself.
Hi, sir. Sorry, I was just waiting for the other participants also to join.
For this program, total students only 3.
Okay. Okay, sir. So I am Jacqueline. I'm working as a lawyer now. I finished my graduation in 2019 as a law student, and I started practicing as a lawyer. I'm based out of Kerala, and my education was done in Chennai. And
Presently, you are from which place? Kerala.
Cochin. Yes.
Then good. We are having Dr. Ramanamurthy. He is the academic counselor. He is going to take the sessions, and then again another session is also there by another faculty. At the time, we will introduce. I think. Please, Ramanamurthy ji, please go ahead.
Yes, sir. I will start. Thank you. Thank you. Yes. Good afternoon to all. Actually, we are having 4 papers in this course exclusively. For that purpose, we have exclusively 2 papers which I suppose to be deal with. Number 1 is overview of the intellectual property rights, and second paper is international framework for patent protection. Especially in the case of overview of the intellectual property rights, basic concepts like what is the general overview of the intellectual property right, what are the Indian scenario of intellectual property rights, how the acquisitions were made, and how the maintenance was possible with regarding to intellectual property rights, what are the latest emerging trends with regarding to intellectual property rights. We should deal with that. And in the same time, we have also another chapter which consists of patent and technology development. So basically, that due to the technology day by day advancement, how the technology promoting the invention of the patents. At the same time, how the technology should be transferred, and while we are more focusing towards the technology, what about the traditional knowledge? We are having a rich heritage of the traditional knowledge. I think so. So, can you please switch off the mic?
Yes, sir.
Okay. So in that case, we should protect our traditional knowledge. And third block is it consists of IPR enforcement. How it is enforced? What in the case of enforcement? In the case of infringement, if anything happens, what should be? Who should be liable? What should be the punishments? What are the remedies for infringement? We are dealing with that. And finally, we are dealing with the litigation in this first chapter. So in the second paper, it exclusively deals with the international framework for the patent protection. For example, WIPO administrative treaties with regarding to Paris Convention, Berne Convention, WIPO mission on structure. Next, we should deal with World Trade Organization along with TRIPS. The last but not least, we are dealing with the patent and biotechnology, genetic resources, computer software. So today's first topic with regarding to the first paper of IPR concepts and forms. So what is intellectual property right? What do you mean by intellectual property right? So intellectual property right is nothing but it is an invention or a screenplay over which rights are granted, maybe termed as intellectual property. So the intellectual properties fall in common domain after a fixed period of time. Except trademark, geo. My voice are audible somehow. Jacqueline, my voice are audible.
Yes, voice is audible. There was a slight disturbance, but it's audible now.
Okay. Then that's why I switch off the. audio, video also. It is better to communicate easily. Voice.
Sir, I'm also I'm in
Okay.
my office right now, so
Okay.
I can
Okay.
it
Okay.
won't be much interactive
Okay.
today. Sorry.
Okay. Okay.
I'll be listening. I'll switch off
Okay.
my video.
Okay. So sometimes I will ask if any whether you are listening or not. Okay.
Sure, sure, sure. Done.
Then it will be
I'll be listening. Okay.
fruitful to the session. Okay. So the IPR is nothing but it is a screenplay or invention for which the rights are granted. So what is the difference between intellectual property and property? So basically, the property means some material which belongs to a particular person. The concept of ownership is crucial to the concept of property. Ownership means the right. Ownership means the right to possess, use, and dispose of the property and exclude the others. If a society does not recognize ownership, it will have no concept of property. In the legal sense, property refers to a bundle of rights that the law confers on a person by virtue of the ownership and possession of an object. So the difference between intellectual property and property, basically, property typically refers to physical possession that can be owned. Intellectual property, on the other hand, refers to a creation of mind, such as invention, literary and artistic works, designs, symbols, names, and images used in commerce. So, what is the difference between tangible and intangible? Jacqueline,
Yes, sir.
can you
Yeah.
explain it?
Should I answer that?
Yes,
Uh, yes. So tangible and intangible are things that you can touch and feel, and the other
yeah,
is
obviously.
not.
Tangible is
Like goodwill.
you can tangible, you can feel real sense touch after touching that. It can be referred as a tangible. If you are not feeling by touching, it is called intangible. So the tangible property has a big advantage over intangible property, the fact of possession of physical object by owner. The intellectual property is the property created by the application of human mind. So it derives the values from ideas. So there may be different categories of intellectual properties. Basically, the intellectual properties are broadly divided into two main branches: industrial property and copyright. Industrial property, it consists of rights relating to inventions, that is patents, trademark, industrial designs, and geographical indications. Copyright protects rights related to creation of human mind in the fields of literature, science, music, art, audiovisuals, etc. Especially the TRIPS agreement of World Trade Organization, it recognizes 7 categories of intellectual property rights. Those are copyrights, trademarks, geographical indications, patents, industrial designs, layout designs, or IC, integrated circuits, undisclosed information. So latestly, there is a new concepts of intellectual property are arisen. The traditional knowledge, also referred to the indigenous knowledge, has been accepted as the subject matter of intellectual property. At the same time, in the USA especially, patenting of business methods have been recognized. Now it is a huge debate. Next area, the law of protection of celebrities or right to publicity is a distinct branch now. It is under discussions right now. At the same time, conservation of biodiversity is also the new concept as emerged as the IPs. So, what are the features of intellectual properties? So, the basic features of intellectual properties is time limited. Intellectual property first feature is time limited. intellectual property, excepting trademarks, are all the time-limited ownership rights. Excepting the trademarks, all are time-limited ownership rights. Number one. Number two, intellectual properties are negative rights. Why? Because intellectual property rights called as a negative rights as a right of the owner to restrain others from doing certain things. So it is called as negative rights. It is another feature. Third feature is concrete public disclosure. Intellectual property recognized or comes into existence only when the ideas or concepts get concretized into tangible form. An expression, an expressed idea has a copyright. If it can be reduced to an embodiment, it can be called as patented. Ideas per se cannot be protected, except to a limited extent as a trade secrets or undisclosed information. So the fourth feature is tool of wealth generation. It creates wealth generation to the person who find or who created the IP, the person who consumed the intellectual property, at the same time, the person who used the intellectual property. So that is the fourth feature. Now the fifth feature is beneficial to the right holders. The intellectual property allows its holder right to exclude other from certain business opportunities. So it is useful for the right holders. The last feature is the intellectual property benefits to society. It benefits to society. The public, by using it, it can right way take steps to benefiting, accruing to the right holders. So these are the advantages. Certain features. So basically the 6 features are given. First one is time limited. Second one is negative rights. Third one is concrete public disclosure. Fourth one is tool of wealth generation. Fifth one is beneficial to right holders. Sixth one, benefit to the society.
Sir, can you repeat the second one once more? The third one, concrete.
Negative rights. First one is time limited. Second one is negative rights. Time limited. Why it is called time limited? Except to the trademark, every intellectual property right give the limited ownership right. For example, in the case of patent, 20 years, like that. So it is called time limited. Second, negative rights. Why? Because it is called negative rights. It creates others not to restrain. It creates others, restrain others from doing certain things with regarding to this subject matter of the IPR. So it is negative right. Third one is it creates concrete public disclosure. You have to disclose once. Whenever you disclose, then it becomes IPR. Otherwise, it cannot. Ideas per se cannot be protected, except a limited extent is given. If there is a trade secret or undisclosed information, that they can grant the IPR, but otherwise they can't grant the IPR. Fourth point is that it is a tool of wealth generation. Fifth point is it is benefit to right holders. Sixth point, benefit to the society. Yes, with regarding to Indian Constitution, what provisions are deal with IPR? Basically, IPR is nothing but property, deals with property. So in Indian Constitution, there is no specific provision mentions regarding intellectual property rights. But property in the Indian Constitution means tangible. So Article 19(1)(g), it exclusively talks about trade, practice, and profess. At the same time, Article 300A, after inserted through the 44th Amendment Act 1978, which added Article 300A, which deals with property and to be entitled a legal right. So, based on these two provisions, the right to property is there in Constitution, not a fundamental right. It is a legal right now. So, Parliament makes numerous laws to protect the intellectual property rights, such as Patent Act, Copyright Act, Trademarks Act, Designs Act, Okay, these all laws provide a framework for the registration, protection, and enforcement of the intellectual properties. So, some of the historical legislations with regard to in India. For example, if you take the patents, the first Indian statute on the patent was passed in 1856. So 1856, the first Indian statute with regarding to patents were passed. In 1856 Act, it gives investors for 14 years as an exclusive right of for that product. Later, so many modifications was done. We are at present after the independence, 1947. We are in 1947 till we are using uh, before the independence. We are using the British patent law, British Patent and Designs Act 1907. But later, in 1947, when the India got independence, we are appointed two expert committees with regarding to these patents. First one is headed by Justice Rajagopala Iyengar, Justice Rajagopala Iyengar Committee, and another headed by Bakshi Tekchand Committee. Bakshi Tekchand. So two committees were appointed after the India independence. That is Justice Rajagopala Iyengar Committee and Bakshi Tekchand Committee. These two committees revealed that the MNCs, multinational companies who owned 90% of the all patents in India, had misused patents largely to ensure a protected market in India for their products. They denying availability of many essential goods to people at competitive prices. So for these reasons, India enacted Indian Patent Act 1970, which is basically it is the Patent Act 1970. It came into force in 1972. It is the most progressive patent law in the world in that time, 1970. So based on this Patent Act 1970, Indian Patent Act 1970, so many other countries also inspired this legislation and they codified this Indian Patent Act as their own patent law. Indian Indian Patent Act 1970 clearly codified inventions that could not be patented, permitted patenting of only process, not products of manufacture in the fields of food, drugs, and medicines, and substances produced by the chemical process. Basically, the term patent in the case of process relating food, medicine, and drug, 5 years from the sealing of the patent or 7 years from the date of patent, whichever is earlier in the case of other process patents. It was 14 years. They give license of right of compulsory licensing. So basically, latest amendment was happened to this Patent Act. Now we are following the Patent Amendment Act 2005 because of after World Trade Organization restrictions given, World Trade Organization some guidelines are given through the TRIPS agreement. So based on that, we are amended our Patent Act 1970. So latest we are following Patent Amendment Act 2005. Trademark. There is no specific existed legislation on the trademark before 1940. Even though we have remedies for violation of the trademark, which was available in Indian Penal Code and a specific relief act, but we are enacted Trademarks Act 1940 first time. Later, again with the compilation of the World Trade Organization along with the TRIPS agreement, we are amended again in Trademarks Act 1999. We are passed Designs Act in 2000. With regard to copyright, we are following English Copyright Act 1842. It was deemed to be applicable throughout the India. The Copyright Act 1911 of the England one extended to India as a British dominion. The Indian Copyright Act 1914 introduced criminal sanctions for infringement and continued till the Copyright Act 1914 introduced. This was necessitated as much by the change status of India as an independent nation, by the advancement of technology of reproduction and communication. So some of the we should see that what are the characteristic features of various laws in India. So with regarding to Patent Act, what are the characteristic features of Patent Act? So first one is the Act introduced the product patents for pharmaceuticals and agrochemicals, aligning India with international patent standards under the TRIPS agreement. The second point is it provides a framework for the protection of pharmaceutical inventions, allowing for the patenting of new drugs and formulations. Third one, this act included provisions for compulsory licensing, allowing the government to grant licenses to the third parties to manufacture patented products in certain circumstances such as public health emergencies. Next, the Act also introduced a mailbox system, allowing a patent applications for pharmaceuticals filed before 2005 to be examined under this new law. And it also established the criteria for patentability, including novelty, inventive step, and industrial applicability in line with international standards. The Act also defines what inventions are not patentable, such as inventions contrary to public order or morality, methods of agriculture or horticulture, and mathematical or business methods. This should be not given the patentable. Finally, it outlined the procedure for filing patent application, examination of patents, and opposition proceedings. So the Indian Patent Act 2005. So the characteristic features are first one, it introduced product patents. Second one, it provides pharmaceutical patent protection. Third one, it gives compulsory licensing. Fourth one, it consists of mailbox system. Fifth one, it provides criteria for patentability. Sixth one, it also provides exclusions from patentability. And finally, it contains filing and examination of procedures. So the Copyright Act 1999. What are the features of this Copyright Act 1999? Actually, the Copyright Act 1990 was not enacted in 1991. The first enactment was 1957 and has been subsequently amended several times. The most recent one is 2012. So, but in Copyright Act 1957, subsequent amendments provide the protection of literary, dramatic, musical, and artistic works. So, the key features of Copyright Act is that this act protects a wide range of works, including literary works, dramatic works, musical works, artistic works, cinematographic films, sound recordings, and computer programs. And it also, Copyright Act also consists the owners are granted exclusive right to reproduce, distribute, perform, and display their works as well as to creative derivative works based on their original work. The Copyright Act also mentioned the duration of the copyright, that is, it lasts lifetime of the author plus 60 years after their death. For anonymous works, copyright protection lasts for 60 years from the year of publication. Next, this Act also includes provisions for fair dealing, and certain exceptions to copyright infringement, such as for research, private study, criticism, review, news, reporting, and education. The copyright protection is also automatic upon the creation of work. So, the Act allows for the voluntary registration of the copyrights with the Copyright Office for evidentiary purpose. The Act also provides some injunctions and civil remedies for anyone infringed the copyright. So these are the characteristic features of the Copyright Act 1957. So first one is the scope of the protection. Exemplified the scope of the protection. Second one is it gives exclusive rights to the owners of the copyrights. Third one, it mentioned the duration of the copyright. The duration of the copyright is last for the lifetime of the author plus 60 years after their death. If the work is work done by the anonymous person, then the copyright protection lasts for 60 years from the date of the publication. It is also the Act includes provision for fair dealing and certain exceptions to the copyright infringement. It also provides some registration, enforcement treaties given as a characteristic features. Now the Trademark Act. Trademark Act 1999. So features of the Trademark Act. The Act defines trademarks broadly and provides for the registration of the trademark, including words, names, symbols, devices, or any combination thereof capable of distinguishing the goods or services of one person from those of others. So, scope of the protection. It extends protection to both registered and unregistered trademarks, with registered trademarks enjoying additional benefits and presumption of validity. The Act also emphasizes the importance of distinctiveness from the trademark registration, requiring marks to be capable of distinguishing the goods or services of one person from those of others. At the same time, the Act outlines absolute grounds for refusal of trademark registration, such as marks lacking distinctiveness, being descriptive, generic, or contrary to the public morality or order. It also provides for relative grounds for refusal, such as likelihood of confusion with earlier trademarks or well-known trademarks. The Act established provision for renewal of the trademark registration, which is initially valid for 10 years and can be renewed indefinitely for a successive period of 10 years. So the validity of trademark is 10 years. Enforcement. It provides for the civil remedies for the trademark infringement. So the Act also addresses the issue of domain name disputes and provides mechanism for resolving conflict between domain names and trademarks. So Trademark Act, it exclusively defined what comes as broadly what comes under trademark. It given. Second one, it extended the protection both registered and unregistered trademarks. Third, it emphasized the importance to the distinctiveness for the trademark registration. Next, the Copyright Act, the Trademark Act also outlines the absolute grounds for refusal of the trademark registration. At the same time, it consists of the renewal and duration period also. The duration period of trademark is 10 years. Next, the Designs Act 2000. The Design Act, some characteristic features is that it defines what comes under design. The Act defines a design as a feature of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional, which gives the article a unique appearance. At the same time, it provides for the registration of designs, which the design office allowing for the grant of exclusive rights to the owner of the registered design. The registered designs are protected against unauthorized copyright or imitation, providing their owners with exclusive rights to use the design and prevent others from making, importing, selling. So the Act requires designs to be new or original to be eligible for registration. They should not have been disclosed to the public anywhere in the world prior to the date of application for the registration. So the registered designs are initially protected for a period of 10 years, extended for an additional period of 5 years upon the payment of renewal fees. So for the enforcement, they have civil remedies for the design infringement, including injunctions, damages, and account of profits, as well as a criminal penalties for intentional infringement of registered designs. So these are the characteristic features of Designs Act. At the same time, major international treaties which was signed by India were the Convention establishing World WIPO, World Intellectual Property Organization. Second one is the Paris Convention, which which uh, which is for the protection of industrial property. Third one, India has also signed the Berne Convention for the protection of literary and artistic works. Next, PCT, Patent Cooperation Treaty. India is also the member of Patent Cooperation Treaty. India also the signatory of the Geneva Convention for the protection of producers of phonograms against unauthorized duplication of their phonograms, and the Budapest Treaty on the international recognition of the deposit of microorganisms for the purposes of patent protection. So, how uh, intellectual property rights should be acquisited and maintained? So, basically, for the acquisition and maintenance of intellectual property rights, every country, every nation starts to establish IPOs, intellectual property offices. So these intellectual property offices differ from one country to another in terms of its organization, structure, and even the tasks it is supposed to be performed. In some countries, intellectual property offices concerned may be confined to the patent, while in some other countries, the intellectual property offices may deal with the whole range of IPs. Especially in India, there is a Controller General of Patent Designs and Trademarks who is also the Registrar of Geographical Indications. So in India, Controller General of Patent Designs and Trademarks is also the Registrar of the Geographical Indications. There is a separate copyright office under the control of Register of Copyrights. At the same time, the Semiconductor Integrated Circuits Layout Designs Act 2000 provides for the establishment of a Semiconductor Integrated Circuits Layout Design Registry under the control of the registrar. So basically, in India, we have three offices. So, like that, in every country, they may differ the functions of their IPOs, intellectual property offices. So, what is the uh, cost for acquisition of the IPOs? With regarding to patents, the cost of acquisition and maintenance of the intellectual property separately for patents, trademarks, and copyrights. For example, in the case of patents, cost of acquisition and maintenance depend on the number of countries in which the protection is sought. Okay, and also on the required number of times of renewal of the patent in each country. It depends on that. So in India, the cost of maintenance and acquisition of the patent depends on the number of countries in which protection is sought. There is a great divergence of culture and value system of the different people, and the development needs of various countries widely different. That means, in the if you want to register that patent in India, again you have to go another country. You want to register. That is the difficult situation. In that way, there is a treaty was happened, PCT, Patent Cooperation Treaty in 1970. So based on this, the members who are involved in the are signatories of the Patent Control Treaty, they cannot register in every country. Those, if any of the member country was registered that patent, the remaining members deems that they are registered under their own laws. So that is patent cooperation treaty. In the case of trademark, compared to patent, the registration of trademark requires a less stringent examination and costless, because the fees for registration of the trademark and its subsequent renewal vary vastly from the market to market, to country to country. A trademark can be protected on the basis of use also, but registration affords full and proper protection to a trademark without undue hassle. Almost all countries have a trademark offices where an application for the registration of the trademark is to be filed. Again, in every country you cannot, it is impossible to file petition with regarding to file a trademark protection. So WIPO, World Intellectual Property Organization members have adopted trademark law treaty in 1994. Okay, which dilutes the registration in each country by simplifying the procedure. For example, the African Intellectual Property Organization, and the African Regional Industrial Property Organization provides a centralized registration system for their respective members. Those who are the parties of that organization, the entire centralized registration was given. At the same time, the World Intellectual Property Organization has also concluded two international treaties providing for international registration system for marks. These treaties are Madrid Agreement concerning the international registration of marks 1891 and the protocol relating to the Madrid Agreement concerning the international registration of marks 1989. So these may be used by residents of and the companies established in that countries party to the Madrid system. So these two, by these two treaties, who are the members of this treaty can apply in any of the country. Then other members treats that it is registered. In the case of copyright, the Berne Convention, which formalities such as registration and a deposit for the enjoyment and exercisement of the copyright, it deals with the Berne Convention. The copyright is seen as a property flowing naturally and without formality from the act of the creation. The copyright is seen as a property flowing naturally and without formality from the act of creation. Act of creation and fixation are inseparable. So copyright flows from the time an artistic idea has been given an expression. So it is from the expression that enjoys copyright and not the idea itself. So this is with regarding to acquisition and maintenance of intellectual properties. So the new emerging issues in the case of intellectual property is the global intellectual property has constantly coped with the new challenges, as on one hand advances in the science and technology gives rise to every new unprecedented issues, and on the other hand new legitimate claims crop up from the commercialization of the knowledge embedded in the traditional system. The information and communications technology and the biotechnology fields of knowledge have seen staggering advances at breathtaking place and have posed new issues before the intellectual property protection. The progress in the field has literally transformed the way one had known the world, transacted business, and carried out the activities only about 25 years ago. Similarly, the research and development is being conducted as mega business. It has brought out predatory forays into commercialization of knowledge embedded in traditional system, and exploitation of cultural heritage of indigenous communities. So these communities are to be considered as owing these resources, and several issues of ethics and equity have therefore come to the fore. So the new challenges, emerging issues with regarding to, we are already tell in the first time, the beginning of the class, because of this technology development, so cyber squatting, so internet domains, these were consequently increasing. At the same time, after the CBD, Convention on Biological Diversity, there is a huge furor in the international market that biotechnology utilizes biological process. It is a technique of use living organisms are part of them and naturally occurring proteins and enzymes. So this protection of biotechnology also rises, because if you see the human genome, so the draft of the genetic master blueprint of the human being is ready. Preliminary sequence maps of the human genome have been made. The question patent to intellectual property are, who owns the data? Are the genes are the parts of the genes patentable? If so, under what conditions? Is the donor of human genetic issue relevant from the IP point of view? If its study leads to a patentable, this last question is practically important because it involves the questions of informed consent and being shared. So patent law is not concerned with the donor consent. Moreover, the developed countries pay regard to the consent and the benefit sharing. There is a substantial opinion against the patenting of genes. It is feared that once genes become private property, full benefits of genome decoding will not be available. So the counterpoint advanced by drug developing companies is that without patent rights, it would not be possible to fund research into the new drug development. So the traditional knowledge refers to the total stock of the knowledge and practices developed and used by a community over centuries to meet different situations. It will include traditional medicine and healing practices, ethical and ethnographic products. So traditional knowledge is out of an indigenous community's observation and experience and expressions of its creative urges in various forms through the long march of history. The traditional knowledge has sustained communities, providing them with source of income, items of food, and other necessities of life, has also effective healthcare in a very sustainable way. So exploitation of nature for personal greed is largely unknown in indigenous communities. Especially the World Intellectual Property Organization and UNESCO have adopted a model law on folklore in 1981 to recognize and protect folklore and knowledge of communities. The WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore, the IGC, was established in 2001 to address these issues in a comprehensive way, and has therefore considered the protection of both traditional knowledge and traditional cultural expressions together with intellectual property aspects of genetic resources. So, what is the patent technology? Especially with regarding to patent technology, then everyone thinks that there is a necessity is the mother of innovation. So, Joseph A. Schumpeter, the famous scientist, in 1911 announced a theory which placed innovation and entrepreneurship at the heart of the economic development. He saw invention by itself as economically irrelevant unless some entrepreneur driven by profit motive would transform it into an innovation which yielded economic benefit. So the contribution of technology progress to economic growth today has to be much larger. Today's economy, particularly in developed countries, is known as knowledge economy, depending heavily on advances in science and technology in all fields of human endeavor. And the advances in science and technology are greatly influenced by the recognition of intellectual property rights, particularly related to inventions and patents. So especially in post 1980, the technological progress as the key factor in economic growth has got more attention. The role of government policy in influencing technology progress have also comes under the focus. From the last decade, we saw the rapid growth in the knowledge revolution simultaneously in several areas, especially in the case of information and communication, artificial intelligence, digital technology, e-commerce, biotechnology, medicine, advanced materials, space engineering, etc. So the IP protection impacts the flow of foreign direct investments into a country. So FDI is closely linked to the inflow of technical and investment in projects of socio-economic development. So a person named Camille, Camille Idris, Camille Idris, in his book Intellectual Property, a power tool for economic growth, WIPO 2004, it states that patents has strategic tool for economic growth perform four functions. First one, they facilitate technology transfer. First one is they facilitate technology transfer and foreign direct investment. Second one is they stimulate research and development in the universities and research centers. Second one is they stimulate research and development in the universities and various research centers. Third one is they serve as catalyst of new technologies and new business. And finally, they empower business, particularly small and medium enterprises, with the regard to the intellectual property asset accumulation. So the patent system tries to ensure an equitable balance between the interest of the investor and the interest of the society through various devices. If the patented invention is a product, the inventor gets an exclusive right to prevent any person unauthorized by him from making, using, selling, or importing the product. If the invention is a process, if the invention is a process, the owner's right prevents any unauthorized person from using, selling, or importing that process. The inventor is obliged to disclose his invention in sufficient detail and in such a manner that a person skilled in the art can use the invention. The term of the right is also restricted a few years, generally 20 years, at the end of which the invention passes off into the public domain. So the objective of a patent system is to encourage creativity and inventiveness in the people and harness its product for generating wealth and public good. Patents impact inventive and innovative activity in two very distinctive ways. One is as an instrument of rights and privileges, and second one is as a mine of technology for information. So the property rights and privileges, the immediate effect of the grant of the patent for the invention is that the inventor is effectively shielded from the heat of market competition if he wants to commercially exploit his invention from the term of the patent. The success of one inventor may often have an inspirational effect to the others whose creativity and ingenuity is channeled into new inventions. For example, Toyota. So, towards the end of the 19th century, there was a significant gap in the loom industry to Japan and the Europe. Efforts of the Japanese entrepreneurs, including Toyota, over the years of catch up with the European industry, failed. In the early 20th century, Toyota invented an automatic loom, improving upon the European loom. So the company obtained a number of patents to complement and fine tune the invention and passed on the exclusive right to manufacture and sell the automatic loom in any countries other than Japan. China and the USA took Platt Brothers and Company for a sum of 1 lakh rupee, 1 lakh euros, which is invested for the further research and development and set up an automobile company. So this is the example of Toyota. So the new technologies and patents. From 1980s, the technology has advanced with overwhelming rapidly and several new fields of technology. They have emerged because of computers, electronics, digital technology, biotechnology, genomics, nanotechnology. Because of these rapid increases, the new technologies also increases. So it affects the new technology brought with the new questions, new dilemmas, and the intellectual property system has to respond with needed dynamic and flexibility. So with regarding to new technology sectors, two two are very considerable thing. That is, one is computer technology, and the second one is biotechnology. So in the case of computer technology, imagine life today without computers. While patent could take inventions in hardware, chips in computers, and other microprocessors, electronic products, a little difficulty in IP production. So in the case of chip industry, the chip, the hard product of the chip comes under the patent protection. But the software, but the while in the usage of the chip, the information is very necessary. So that the chip software protected by the copyright. See, the focus on the research is the computer industry today lies in the software domain. Thus, in a few countries, the computer hardware and software are protected by the patent law and the copyright law, and which the law will apply in particular case depends on the nature of intellectual property at hand. The case of biotechnology, it gives hold to its next major level industrial wave after computer. Biotechnology harnesses biological processes in living systems. Advances in human genome sequence and animal plant genetic projects. An infinite potential for biotechnology in discovery of new drugs, treatment of diseases and disabilities, and also in agriculture and development of food products and seeds. A new field of proteomics, which deals with the relationship of genome and proteins, is emerging. So it requires use of supercomputers. Sophisticated techniques like recombinant DNA, self-fusion, embryonic manipulation are regularly employed as a research tools in biotechnology. The point of interest for us is that besides a high degree of knowledge and skills, biotechnological research is highly capital intensive. To attract private investment in biotechnological research, as indeed for all other research requirements, large investment of capital, protection of intellectual property becomes an absolute necessity. Encouraging invention in agriculture through protecting it as intellectual property offers to hope to overcome problems of food shortage and malnutrition, which have so persistently plagued the developing countries. The agricultural research and development in developing countries is largely done through the public funding. Patent technology development. In the patent technology development, what are the privileges useful for first licensee? The first licensee, a newly developed technology from a university or a research institute, has to invest huge sum to adapt and develop for commercial product. This investment may be of the order of 50 to 100 times the cost of the licensing. So, in view of this, the licensee may ask for exclusive rights over the technology. So, various countries adopt different patterns in the licensing due to their convenience with regarding to their development and technology transfer. So, why should technology transfer? What is the need of transfer of technology? So, there should be a technology transfer. For the first license of the patent, can has to invest huge amount, which he may be 50 to 100 times of the cost of the licensing fee. So the inventor allows others to some extent by taking monetary benefits, make contract with others. To keep the cost of technology is low. So the transfer technology should be transferred. So in the case of transfer, the legal relationships are essentially contractual in nature, which means that the transferor of the technology consents to transfer and the transferee consents to acquire the rights. So this is one of the legal instrument for the technology of the transfer. So the legal relationship with regarding to the technology of transfer is that the transfer of the technology consents to transfer and the transferee consents to acquire the rights. The assignment is the first legal method. Is in the first legal method, the sale by the owner of all his exclusive rights to a patented invention and purchased to those rights by another person or legal entity. When all the exclusive rights to patented inventions are transferred without any restriction in time or other conditions by the owner of the patented invention to another person or legal entity. So the legal document is known as instrument of assignment of patent rights. Is the first legal method of transfer, and the second legal method is the license contract. The permission by the owner of a patent invention to another person or a legal entity to perform in the country and for the duration of the patent rights one or more of the acts which are covered by the exclusive rights to the patented invention in the area of country. The making of the products by the process that includes the invention or the use of the process that includes the invention. So the legal document known as license contract, the owner of the patent invention who gives that permission is referred as a licensor. The person or legal entity who receives the permission is referred as licensee. So tools for technology transfer. What are the various tools used for technology transfer? So the tools for technology transfer is sale, purchase, import of equipment and other capital goods, franchising and disbursement at the same time, joint venture agreement. These are the tools which used for the technology transfer. So there are some steps which are involved in the technology transfer. For the successful transfer of technology, a number of activities have to be carried out. Not all of which are sequential, but it is also important to note that while the scientist who has developed the technology can carry out some of these activities, those are technology evolution, determination of market potential, preparation of comprehensive documents and laboratory notebooks, measures to protect the technology and formulating a strategy of IPR protection, preparation of project reports, identifying potential licenses, preparation of proposal for obtaining financial assistance, provide assistance in carrying detailed design, and provide assistance for erection, testing, and commissioning of the manufacturing plant. So these are some of the steps involved in the technology transfer. So in the case of technology evolution, the technology evolution consists of two aspects, that is technical aspect and commercial evolution. The party who is interested in the technology would first of all like to have a detailed presentation on all the technical aspects of the technology. You will agree that all scientists try to give the minimum information in the patent documents. In the case of determination of market potential, a buyer of technology is interested in knowing the market potential of the new product. He wants to know about all the different possible applications. Will the new product be able to compete with the existing products in the terms of quality and prices? Are there any entry market barriers? For instance, to introduce a new Coca-Cola type drink, the licensee may require to invest millions of rupees in the advertising alone for the products of succeed. For example, if you see the Pan Masala advertisements, all the celebrities is promoting the Pan Masala. The companies invest most of the money on the advertisements only. The only one cricketer, you can call it as the god of the cricket. Except him, every cricketer is doing some tobacco ads. So these tobacco companies, a lot of money paid towards the advertisement. So, with regarding to the protection of traditional knowledge, so the traditional knowledge is a part of cultural identities of indigenous and local communities. The protection of this traditional knowledge system is vital for the very existence of the indigenous and local communities, because the traditional knowledge is receiving increasing attention in international agenda in recent time. The World Health Organization has stated that 80% of the world's population depend on traditional medicine for its primary health care, and that traditional knowledge is indispensable for its survival. So, population using traditional medicines for the primary health care include Ethiopia. 90% of the people are using this traditional knowledge. India is 70%, Rwanda is 70%, Tanzania is 60%, and Uganda is 60%. These are all developing countries and below developing countries. Most of the countries are used the traditional knowledge as their primary healthcare centers. Any form of treaties and emerging international norms. There are a number of reasons why developing countries want to protect their traditional knowledge. So the traditional knowledge is used as input into the modern industries such as pharmaceuticals, botanical medicines, cosmetics, and toiletries, agriculture and biological pesticides. So a number of field studies has proved that the conservation of ethnic is a prevalent feature of subsistence and resource management practices of many present-day indigenous or native people and traditional communities. Much of the world crop diversity is the custody of farmers who follow age-old farming and land use practices in ecologically complex agricultural system, which enable the conservation of biodiversity. So, what is biopiracy? So, you all know that what is biopiracy. So, to protect this biopiracy, the biopiracy is nothing but to exploitation of the biological resources. It is normally refers either to unauthorized extraction of biological resources associated with traditional knowledge from developing countries is known as biopiracy. So this many incompatibilities between traditional knowledge and intellectual property rights have begun to surface with the rapid global acceptance of Western concepts and standards of intellectual property. These incompatibilities appear when ownership of traditional knowledge is inappropriately claimed that belongs to local communities, primarily in developing countries. The codified traditional knowledge has also become an open treasure for misappropriation. Since this knowledge exists in local language and in format not understandable to patent examiner, patents have been obtained on this knowledge. For example, turmeric, here called as haldia. The rhizomes of turmeric are used as a spice for flavoring Indian cooking. It also had properties that make it an effective ingredient in medicine, cosmetics, and as a color dye. As a medicine, it has been traditionally used for centuries to heal the wounds and rashes. Especially in 1995, two expatriates, a person who living outside their country, Indians, at the University of Mississippi Medical Center, were granted a US patent on the use of turmeric in healing, wound healing. The Indian Council of Scientific and Industrial Research (CSIR) filed a re-examination case with the US Patent Office, challenging the patent on the ground of prior art. CSR argued that turmeric has been used for thousands of years for healing wounds and rashes, and therefore its medicinal use was not a novel invention. The turmeric case was a landmark judgment case, as it was for the first time that a patent based on the traditional knowledge of a developing country was successfully challenged. So the Patent Office of US revoked this petition in 1987 after ascertaining that there was no novelty. The findings by innovators having been known in India for centuries. So in the case of neem extracts can be used against hundreds of pests and fungal diseases that attack crops. The oil, which was extracted from the seeds of the neem, can be used to cure cold and flu. It also neem mixed in the soap provides relief from malaria, skin diseases. So in 1994, European Patent Office it granted a patent to the US corporation WR Grace Company and US Department of Agriculture for a method for controlling fungi on plants by the aid of hydrophobic extracted neem oil. In 1995, a group of international NGOs and the representatives of Indian farmers filed a legal petition opposing this patent. They submitted evidence that the fungicidal effect of extracts of the neem seeds have been known and used for centuries in Indian agriculture to protect crops. And thus, prior art and unpatentable. So in 1999, the European Patent Office determined that according to the evidence, all features of the present claim have been disclosed to the public prior to the patent application. So the patent granted on neem was revoked by the European Patent Office in March 2005. At the same time, another one which makes vulnerable to India is regarding to basmati rice. Rice Technical Corporation had applied for registration of a mark, Texmati, before the UK trademark registry. It was successfully opposed by the Agricultural and Processed Food Exports Authority. On the documents relied upon by the Rice Tech as evidence that the support for the registration of the said mark was US patent grant by the US Patent Office Rice Tech. So this was also successfully defended by the Indian Agriculture Research Institute by collecting all the evidence and submitting before that. So through various petitions in 2000, the Rice Tech chose to withdraw its contents of the claims by saying Texmati, registration of a mark of Texmati regarding to basmati rice. So, especially in 1980, the WIPO and UNESCO adopted a model law on this traditional knowledge. In 1989, the concept of farmers' right was introduced by the Food and Agriculture Organization. In 1992, the Convention on Biological Diversity recognized the need to promote and preserve traditional knowledge. At the same time, in 2001, Doha Ministerial Conference, the World Trade Organization's Doha Ministerial Conference, broadened the discussion and stressed the need for further work with regard to the traditional knowledge, protection of traditional knowledge. So, Global Biodiversity Forum in 2003 in Mexico, Cancun, emphasized that economic growth must take place within the natural limits of ecosystem while respecting the environment at all times. The global risks, the global issues, the implementation of traditional production is first one, risk, precaution, and biosecurity. There is no global consensus on where the delicate balance lies among risk, precaution, and biosecurity. At the same time, prior informed consent means the consent of the government and other stakeholders, which must be obtained prior to the access to genetic resources and based on the full disclosure of information. Several international instruments that supports recognition of the rights of indigenous people and other local communities prior to informed consent. The registered genetic resources and focus on the especially the India, what steps taken towards the protection of traditional knowledge. India developed a traditional knowledge digital library with an objective of defensive protection of the codified traditional knowledge on Indian system of medicine in our country. Any area of industrial application which has to be examined by the patent office needs to have been a structured classification basically for the retrieval of the data. So traditional knowledge of digital library, which was started after the World Intellectual Property third plenary session in 1999, established in 2000. The main objective of this digital library, traditional knowledge digital library, is that to prevent misappropriation of India's rich heritage of traditional knowledge. India had the unsavory experience of nothing the grant of wrong patents on turmeric by US Patent Office and neem by European Space Office. So by time to time, they are uploaded the traditional knowledge journals, patent cooperation treaty journals, which was mentioned regarding to the traditional knowledge. So for this, we are concluding today's lecture. We are broadly discussed the overview of intellectual property rights. What is intellectual property right? Okay. First, we have discussed what is intellectual property right and what is the difference between intellectual property right and the property. And we are also discussed various types of intellectual property rights, which were largely developed after the 19th century, evolution of the 19th century. And at the same time, we are discussed the uh, intellectual property right relation with the Constitution of India and various intellectual property legislations in India. Friends, are you there?
Yes, sir. Listening.
Yeah. So we are at the conclusion topic. Today's conclusion, we are dealing with what is intellectual property right, and at the same time we distinguish between intellectual property and property. At the same time, we discussed the characteristics of intellectual property, discussing the characteristics of intellectual property. At the same time, we are discussing with the intellectual property and Constitution of India. Along with that, we are clearly somewhere we are discussing the characteristics of various legislations which were enacted by India for the protection of intellectual property rights. That is, for the Patent Act 2005. What are the characteristics of Patent Act 2005? What are the characteristics of Copyright Act 1999? Characteristics of Trademark Act 1999? Characteristics of Design Act 2000? We are discussing. And after that, we have discussed the acquisition and maintenance of intellectual property rights. So, for this acquisition and maintenance, we are having intellectual property offices. Okay, so how they are intellectual property offices were established? Country by country, differs the constitution and structure and organization of the intellectual property organization. In the country itself, there differs so many offices for deal with the various IPOs. So, what are the costs with regarding to patents should be registered and maintained? What are the cost for the copyright trademark to be registered? Next, we are deal with what are the emerging issues of intellectual property. The emerging issues with regarding to intellectual property is that the domains internet. So domain names, how the domain names were disputed, what factors should include in the nature of disputes. At the same time, some old intellectual property organization guidelines with regarding to internet. At the same time, the new emerging technology of biotechnology with regarding to human genome and traditional knowledge in the new emerging technology we are discussing. Later, we are discussing the patent and technology of development. How the patent how the patents technology increased. For increase of the patents, what technology must be, how the technology is transferred from one to another. Why should the technology should transfer? For that technology transfer technology, for any we are making an example of Toyota of Japan. It consists of the loom industry. At the same time, we are also deal with the technology, new technology transfers with regarding to the computer technology and biotechnology. Especially in the case of computer technology, we are dealing with the chip industry. Biotechnology, we are dealing with the proteomics. At the same time, we are discussing the privileges of the first licensee. Why should the technology transferred? We are discussing. What are the tools for the technology transfer? We are discussing. Later, we are also discussing the steps involving the technology transfer. Steps, especially technology evolution, determination of market potential. We are discussing the this pan masala advertisements, how the all celebrities, all famous persons are run behind these advertisements, and also the protection of traditional knowledge. What is traditional knowledge? What are the benefits of the traditional knowledge to the economy? Conservation of environment. If you conserve the environment, it will give more to your future. So we are dealing with biopiracy. Biopiracy, which is normally refers to the unauthorized extraction of biological resources associated with these technology, traditional knowledge. We are dealing with so many cases with regarding to how the turmeric was registered in USA by US Patent Office, how it was defended and make we as it is we are defended that is not a novel feature, novel innovation. At the same time, the registered name as a patent under the European Patent Office. Again, the Indian afforded to defend that it is following a practice of India since so long years back in the agriculture. So you cannot grant any patent to that name. And also the latest case of basmati rice. So basmati rice was making as a Texmati rice before UK trademark registry. So in there, how can they later converted as basmati rice as how India defended to fight. Finally, in 2000, the rice tech company withdrew the consent. Later, we are discussed with what are the developments with regarding to the protection of traditional knowledge, especially in the case of international scenario, WIPO, UNESCO, World Trade Organization's Doha Ministerial Conference. At the same time, Convention on Biological Diversity, Global Biological Diversity Forum. These are uh, some laid down some rules regarding the protection of the traditional knowledge, especially in the India. What done for the protection of the traditional knowledge? They are developed traditional knowledge digital library in the year 2000 for the network project to prevent the misappropriation of India's rich heritage of traditional knowledge. So this is for today's class. Tomorrow we will deal with IPR enforcement IPR enforcement along with settlement of disputes, litigation and settlement of disputes. Okay? Do you have any doubts?
No, sir.
regarding this? Okay. Who is the other one? Isabel.
Yes, sir. No doubts. Thank you.
Okay. Thank you. Tomorrow we will
Thank you
meet
so
at
much.
2 o'clock. Okay.
Sure, sir.
Okay.
Yes, sir.
Okay. Done. Thank you.